assuming that the briefs have been reviewed, it's not that complicated of a case. Mr. Ordonez, he pled guilty to a state jail felony possession. And in September of 2019, his probation was revoked and he was sentenced to 18 months state jail division, TDC. That was September. 2 weeks later, he filed a notice of appeal, or his lawyer filed a notice of appeal on his behalf. And he also, a $10,000 appeal bond was set, which he made. He made that appeal bond. And that was September of 2019. And from that time until, let's see, February, I believe, of 2025, the notice of appeal was never forwarded by the clerk to the Court of Appeals. So he has been out on bond. That's undisputed. He's been out on bond. There's another thing about that point that I may bring up later, or I think I should later, but at this point, he was out on bond. So the question as to why the clerk did not forward that to the Court of Appeals, that, as the state points out, that is not in the record. The trial court obviously lost jurisdiction over the case after the motion for new trial was overruled as an operation by operation of law. So there was no opportunity to put anything of record because this all occurred long after the trial court lost plenary power.
Well, and it also occurred long after the notice of appeal was filed.
Long after the notice of appeal was filed, correct. There's no way that he could have known at the hearing when sentence was imposed. There's no way that he could have known this was going to happen months, years later.
One of the factors, I'm sorry, Judge.
Can you, on a direct appeal, challenge a process that did not exist at the time?
That is a very good question. Can we challenge what happened after the sentence was imposed? Is that the question? Should this be a writ? Is that the question?
Yes.
All right. Well, that's a very good question, and I don't know. He is not incarcerated at this point. He's not incarcerated at this point. There is no. I'll tell the court what I know. Keep in mind, I was appointed in October of last year, and when I made inquiries, there was nothing here at the Court of Appeals, and the clerk, the deputy clerk that I spoke to, said the file was closed. So I went to the judge in Plainview and spoke to his assistant, who's a very capable lady, and she said, just wait till the Court of Appeals. We're working on this. We're working on this clerk in Castro County.
The El Paso court in CUDA talked about the Barker against Wingo factors. One of the factors that we look at is whether the appellant asserted a timely or a speedy appeal right.
Correct.
Is the record reflect at any point in time your client ever requested a speedy appeal or complained about the length of time?
I don't show in the record anywhere other than it would be clerk's record beginning on page 129, which was the motion to withdraw as counsel filed by the lawyer that was appointed to him, and Troy Bollinger. Mr. Bollinger says in this that he made inquiries and he filed some. He said he filed something. I'm not looking at this exactly, but he made inquiries and was told that the file was closed by the clerk's office. This is, I think that's page 130. Which is not.
That's the only thing in the record that indicates that the file was closed, was the motion to withdraw.
That's correct. I don't see anything where it actually says the file is closed. I can say that I was unable to file a notice of appearance. Now, I'm not sure that I even needed to, because the court ordered and the reason Troy filed this was because he had to withdraw because he moved to Houston. So like in October. So that's the reason he filed this motion to withdraw.
You were unable to file the notice of appearance because the clerk refused for you to do so, or because of the electronic filing process, or?
I don't know. I was told when that occurred by my paralegal advised me that occurred. That was that day that I spoke to the judge's coordinator and said, I can't find stuff on this. I'm afraid, am I missing a deadline? Am I screwing something up? And so she did some work and said, just wait, we're taking care of this.
The remedy that you seek is a remand.
Correct.
For a hearing to see whether the clerk not sending us the notice of appeal immediately was a violation of his due process in some way.
Correct.
How, do you have any cases that support, say it is a violation of his due process, how that would affect the underlying conviction?
I do not have a case that says that. I think the question is there prejudice? Did he suffer some damage, some harm as a result of there not being a timely transmittal of the notice of appeal? Is that the question?
A roundabout.
Well, and so the case law indicates that we would look at three things: whether his incarceration pending appeal was oppressive. Well, we know he wasn't incarcerated pending appeal.
Not in Texas.
Okay. And then anxiety and concern while awaiting the outcome of the appeal, which you referenced, I think, that he's moved on with his life.
I haven't ever had an opportunity to put that on the record. I would have to go to the finder of fact, put on the record and let the trial court, that's part of the request for remand.
And then impairment of appellant's grounds for appeal or the viability of his defense in case of a retrial. I mean, you've not challenged, or have you challenged error in the trial court with regard to the underlying judgment?
I have not challenged error with respect to that. I have not.
Okay, I understand your answer now. You're saying you need to have a hearing on remand to put on evidence of prejudice.
Correct.
On that note,
And to let the trial court evaluate the character of the witness to determine if they're telling the truth and enter a finding of fact and conclusions of law, and then appeal from that. But anyway, I didn't mean to cut you off.
on that note, in reading your brief, I know this is all outside the record. And it says, however, appellant has continued with his life, borrowed money to purchase a tractor trailer rig, married, had children, made other commitments. When I read the original trans record, it seemed like he was already married. Is this, I mean,
I can't remember if he was married and then married again. I don't remember the answer to that. Again, I think that's something that the trial court, I think in order to appeal anything, the rules say as a prerequisite for appeal, you have to present it to the trial court, have the trial court make a finding of fact, and then we know the standard, we know what he used, then I can appeal it to this court. But in connection with whether the delay caused harm to him, I didn't know this until about a month ago because it just didn't come up. I have been in contact with him throughout, but about, I don't even know exactly the period of time, but not long after sentence was imposed, he was incarcerated in New Mexico on an unrelated crime. That's not in the record, but it would be easily proven. I don't even know for sure how long he was incarcerated there. But what I do know is he was on bond. And it's my belief that if he was incarcerated in New Mexico and there's a judgment already entered against him, then his bondsman, had there been an open file in the court with jurisdiction, could have surrendered his bond and he would have gotten credit for the time that he spent incarcerated in New Mexico on the matter in Texas on this exact cause note.
On that
And,
note,
and in that way, in that respect, the judgment, the punishment, his jail time credit would be much higher, months and months higher. And that's another reason that I believe the trial court should revisit this, but pardon me.
on page 41 of the record on your jail time credit, this is where the trial court sentences. And he says, any reason I can't sentence you? No. Okay, I'm going forward. It says, now then, sir, you'll be given credit for any time that you've spent in jail awaiting the sentence, awaiting the original trial of this matter. And then here's where it gets interesting. And any time since you've been on probation awaiting this proceeding. Any clarity to what that meant? I mean, he was on probation for 15 months. He got sentenced to 18. I just haven't seen that before.
I don't think it's normal that you get jail time credit for the time you spent on probation. And I must confess, I wasn't his lawyer at that hearing. That was 5-6 years ago. And I guess I read that part and missed it. I didn't see that. But at the time where he's talking about the jail time credit, he hadn't had what I think could have been credited because he hadn't been incarcerated yet in New Mexico on that unrelated charge. I think that happened in 2020 or 2021. He's been out for at least 2 years now, I believe. So if there is, and I think there is, a requirement of harm, then I think his harm, at least potentially, I don't know, the trial court may listen, may make the determination, factual determination, no, there's not a set of circumstance under which you could have been credited with the time you spent in jail or incarcerated in New Mexico. So he rules against him. He could, the trial court may make that factual finding. If he does, then we can appeal that. Sentencing.
Well, the judgment that is before us now is with regard to adjudicating him on the and revoking the community supervision.
Correct.
And that's not been challenged.
It revokes his community supervision and sentences him to 18 months.
And that's not been challenged. That's the issue before us with regard to the underlying judgment, isn't it?
It is. Okay, the way I see it, and it could well be wrong, but the way I see it is that judgment, he's entitled on that judgment to an appeal. Right? He's entitled to due process of an appeal.
Yes.
Okay. And if he did not receive due process on that appeal, and in connection with that, there was a delay that was unreasonable, and he can prove those 4 factors, then that judgment.
Would you agree here that say they did send the notice of appeal immediately and we get it, and then we sit on it for 5 years and don't issue an opinion? No problem with that, right?
Well, I take the 5th on that. I'm not sure. I mean, appeals take a long time sometimes. I've had some in the federal courts that took forever. I don't know. I can't find a case that says you're entitled to a speedy appeal. I can't find a case that says that. It just says due process. But in this regard, because it's such an odd circumstance, I don't think it's going to happen that often. But the judgment against him was an appealable judgment. And there's no way for him to know that he was going to, in the future, have failed to receive due process on the appeal by the clerk's inaction for 5 years. So he couldn't put any of that on the record. So a judgment in which you did not receive due process right to appeal, I believe I have challenged the underlying judgment.
Well, but I think the CUDA decision out of El Paso undermines what your position is on it, because in that case, that court went through those very factors and said, well, there's no evidence of prejudice of this, and there's no evidence of prejudice of that. That was all on direct appeal. And I think the same argument would have been made in that case, which is a defendant is bound by the record at the time, doesn't have any ability to produce that on appeal. And at least the El Paso court said, on direct appeal, there's no showing we're going to send it down the road. So I think that gets back to what Justice Parker was asking about a while ago, which is, why is this not better handled at a habeas stage when you've got a full opportunity to develop the record?
I'm not saying that it's not. I think that this court can handle it though, because this court has jurisdiction, and the court has jurisdiction in this cause number. And in this cause number, he did not receive due process in the appellate regard. He didn't receive.
We address any potential issue regarding the clerk's failure to forward the notice of appeal timely.
How is that addressed?
Yes.
Is that the question? I can only state that the clerk failed to forward it in this cause number. As a result, that is a denial of due process in this cause number.
Well, couldn't or shouldn't, I mean, we certainly didn't know about it
Certain.
for five and a half years, but we took action as soon as it was filed. The people who knew about it was the appellant, the appellant's attorney at the time, which was not you. The bond company, I guess, would have known, presumably. I mean, how do we keep this from happening again? Or what can the court do about that?
That's a very good question. I just found it and promptly lost it. In the rules of appellate procedure, it states who has a responsibility to determine or to ensure that the clerk complies. I think I just found that. You guys probably, the court knows that far better than I do. I think it says the courts are responsible to ensure compliance.
Well, we have a duty to, along with the trial court, to ensure that the court reporter files a record.
Okay.
And a lot of the cases that we look at that have talked about when there's been a deficient process within the appeal have to do with reporters' records. But there's still an underlying need to show prejudice.
Right. Well, what I'm arguing, what I'm contending is that the prejudice is, at the very least, the prejudice is in the amount of sentence that is left to serve. Potentially, I can't, because the record's been closed for 6 years, I can't cite the court to the record. All I can say is that there would have been a procedure that he did spend time incarcerated in New Mexico. There would have been a procedure to surrender bond and get credit for that on this 18-month sentence if the clerk had done what she should have done.
Does the record reflect when that offense occurred?
No, I don't even know when that offense occurred. I don't know if it was before or after.
Well, to me, that seems like it would be significant if he committed the offense during the time he was on bond during the pendency of the appeal, and I wouldn't think he would get credit for something he did while he was out on bond.
If his bond was surrendered then Castro County puts a hold on him. And if there's a hold on him in that cost number, I don't think that matters whether the crime was committed before or after. I don't but I'm no expert on that.
Your time is up. You'll have an additional 5 minutes.
Thank you, Your Honor.
Hamlin,
May it please the court,
Hamlin.
counsel. First, I want to say thank you for the opportunity to be here. I've been in office for 13 years and this is the first time I've been in front of you. So I thank you for that. And this is an interesting case to be here on. It does involve a very unfortunate set of circumstances where our prior clerk did fail to submit that notice of appeal in a timely fashion. That delay is significant. I don't think anybody's questioning that at all. But the question before you is whether that is a due process violation. And I think that's what this boils down to. And the cases that deal with the speedy appeal issues provide a framework for us to go by to evaluate whether it was a due process violation.
At least when we talk about the Fifth Circuit, the federal court's interpretation of the Constitution and Ruark, the court said that the delay of sending a record for 2 years, they at least presumed without deciding that that was a violation of due process. We've got 3 times that amount here.
Mm-hmm. I think most of the cases, and some of them were 1 year, some of them were up to 3 years. They all said that that is just one of the factors and it is not the deciding factor. But under the Barker analysis, there's the 4 different factors that you look at, and that is one. And that certainly does weigh against the state and for the appellant in this issue. However, I don't think it's the deciding factor, and the others, specifically his assertion of the right to a speedy appeal and the prejudice certainly weigh against him because he did not assert his right to a speedy appeal. We have over 4 years where there were no filings. So his attorney filed the motion for the free reporter's record in December of 2019. And then there's not another filing in the case until October of 2024 when he filed the motion to withdraw.
Is Wingo a habeas case?
Barker v. Wingo,
I'm assuming it is
don't know.
because
I'm
the
sorry.
government's not listed as one of the parties in the case, but I'm trying to figure out how prejudice can be proven during a direct appeal.
Well, for example, CUDA and Sparkman, they look at, and these cases from other states as well that involve the speedy appeal process, they look at the existing record and they say that you can evaluate the factors based on the existing record. They don't remand for a hearing to develop prejudice after the fact. So none of those cases do that. The appellant cited to De Leon and Reyes, which were speedy trial cases where the trial court dismissed those cases based on a speedy trial motion. And in both of those cases, the appellate court did send the cases back and say, hey, you need to have a hearing because the only information the trial court had was the length of the delay. However, in Taylor v. State, which is a 2023 Court of Criminal Appeals case, the Court of Criminal Appeals said there is no actual requirement for the special speedy trial hearing. You can evaluate those Barker v. Wingo factors based on the record in front of you.
How does somebody do that? Because if the notice of appeal is filed, trial court loses plenary power to handle anything. So the case is presumably pending in our court, even though we haven't received it yet. How does an appellant have the ability to put on evidence because it can't be heard in the trial court?
Well, I think he could have filed a number of things. He could have filed something with the court, some sort of mandamus petition to urge the clerk to do her duty and send the appeal. He could have asked the court to hold her in contempt for not performing her statutory duty. He could have filed an inquiry, a letter, I mean, an email,
Could the state
anything.
have done that as well?
Yeah, I think that's a good question. The state could have done that.
Because whenever Justice Parker was going over the people who knew about it earlier, the state also knows about the appeal, but they don't follow up either.
Right. And I will say hindsight's always 20/20. But in 2023, when it was brought to my attention, it was, the notice was filed in 2019, and frankly, it just went off my radar. I assumed that things were happening, or, things would happen as they should, and wasn't focused on that. And so then in 2023, when it was brought back to my attention, I did attempt to urge the clerk to send the notice. However, I did not do that in writing, and I did not file it. But the thing that is important is in these cases with the where the courts are performing this Barker analysis, the that assertion, that responsibility to assert the right to a speedy appeal is placed on the appellant. It's not placed on the state. It's his responsibility to pursue his appeal. So
The appellant seems to contend kind of a detrimental reliance on the closing of the file in the clerk's office. Can detrimental reliance on an erroneous designation by a district clerk constitute a violation of due process?
I don't know that any of the cases speak directly to that. But I don't think so when you look at everything else. When you look at, the fact that he did not assert his right, when you look at the prejudice categories, those categories include, and I think you mentioned them, the oppressive incarceration, which there was none here. The anxiety and concern, which I think the record speaks to the opposite of that. If he was concerned, I think it reasons to say that he would have been following through with that. And so he wasn't necessarily relying on that. I think and the record's not silent about that. His first appellate counsel's motion to withdraw speaks to the fact that he knew the notice had not been sent. And it says in 2021, he lost contact with appellant. And I think it goes to reason that had appellant been concerned with the appeal, he would have been pursuing that, staying in contact with his attorney and trying to push this appeal forward.
I'm just gonna ask a practical question, just because I'm curious. If he was incarcerated in New Mexico during that time, how does it work with his appeal bond? I mean, I know he talked about it can be surrendered or revoked. Is there a system that checks that, or how does that work practically?
I feel like that responsibility goes to appellant and the bondsman, because he should have been checking in consistently on that appellate bond. And
I
so
didn't find that was a condition like what it is in the community supervision order. I'm just.
I mean, typically there's an agreement between the defendant and the bondsman, and the bondsman typically requires them to check in. They have payments and all of that they have to perform throughout that period. And so I think that's part of their responsibility to hold on.
I'm saying, is there like a system in Texas that alerts law enforcement or alerts district attorney's office or county attorney's office, says, hey, this guy who's on bond has been incarcerated somewhere else? So there's a system that flags that or something?
Not that I know of.
Okay.
Now, if his bond was surrendered, we would have had the notice of that, because it would have been filed into that case. But as far as them communicating between sheriff's office or something like that, there's not that I am
Would it
aware
have
of.
been filed in the case if the case was showing closed?
It still would have been filed because it would have been under that cause number, and I think it would have flagged the issue again, and been something we could have acted on at that point. And he's right, there would have been a hold placed on the appellant had his bond been surrendered in this case, and he was incarcerated in New Mexico.
There would have been a hold put on him.
Yes, there would have been.
What about the statement of that he could have possibly received credit for that?
I think he probably, I mean, I'm not 100% certain. I think he probably would have received credit because typically the judge does make the announcement, and I didn't go back and check the record, but he typically announces that it would run concurrent with any other sentence he may serve.
And I
And
think,
so,
yeah, I think he
Yeah.
said that.
He does. It's right after and I'll ask you the same question, but he
Okay.
does say your sentence will also run concurrent with any
Mhm.
time that you might be spending, that you might be serving from another court or jurisdiction. But that's right before the statement of, I'll give you credit for any time you've been on probation awaiting this proceeding. Any thoughts?
I feel like that may be a mistake or like a misstatement in the record, because I mean, I've been through several of these, and so I know their kind of script is they get credit for any time spent in jail awaiting the hearing on the motion to adjudicate.
And he says that.
Oh, he does say that.
It says, I'll give you credit for any time you've been spent in jail awaiting the sentence and awaiting the original trial of this matter, and any time since you've been on probation awaiting this proceeding.
Okay, that I don't have an answer for that. That is not typical and not something I think that they would normally get credit for. I'm not sure why that's in there. I certainly missed that as well. And I don't think it would be I don't think that's provided by statute for them to get that credit. So I really don't have an answer to that. I'm not sure why that's there.
Would you agree that if the appellant is entitled to credit for time he's being held in New Mexico, that that's something he cannot put on as evidence in this case because the appeal is already going on?
Yes, I don't think there's a avenue for him to do that.
Ordinarily, let's in an ordinary appeal where there's a 1 year period of time or less, if something like that occurs, how does that additional credit get credited? Does it simply go to Department of Corrections and they consider the additional time? Does the judgment have to be reformed?
I think typically the judgment is reformed. There's a nunc filed with the adjusted time credit. I don't know that I've actually seen that where they're on an appellate bond and then they are incarcerated somewhere else and get credit for that. So I can't speak from experience, but typically if there is a problem with time credit, which happens frequently, then yes, the judgment is reformed to fix that.
Okay.
So kind of back to the Barker factors and looking at prejudice, I think it's important to note that one of the most important categories that the courts look at in these speedy appeal cases is the impairment of the appeal. And he didn't write on any other issues in his brief. And so there's nothing else. The record is intact. There's no claim that anything else is impaired. And in COA, that court indicates that the absence of a viable appealable issue strongly indicates that there is no prejudice. If this appeal was timely sent, I think it would have ended with an Anders brief and an affirmation of the trial court's judgment. It was a revocation hearing. The probation officer's testimony was mostly uncontroverted. Appellant did plead not true, but he testified, admitted to some of those violations. That's all it takes to revoke the probation, is at least one violation. So the judge sentenced him within the range. I don't think there was any other appealable issues here. So that fact.
Except the state could have appealed saying he's not entitled to the credit for while waiting on
Well,
probation. May not have been an Anders.
that is true. I mean, that's a good.
So when I initially read this case with this briefing, it reads just like a writ to me, which we don't handle.
Mhm.
Okay, so all this stuff is outside the record.
Mhm.
When I initially read it, it says, oh, so I thought it read since the sentencing, he has married, has kids, got a loan for a tractor trailer. It sounded like the appeal bond was the best thing for this guy. He's rehabilitated himself. And so I was curious if the state was even interested in going forward with having him serve a sentence. Is that?
Um, I think that's a difficult question to answer. I think it's important for people to be held responsible for their criminal actions. Obviously, as a prosecutor, you know, I hold that position. I also think you have to weigh, you know, what is justice in this situation? And it's not an easy answer. I don't know that him serving that sentence is the best thing for him, but under the law, I do think that it is the required thing under the law. He has that sentence and he has not served it, and therefore he is supposed to. And I don't think that he has proved a due process violation here, and that the judgment should be affirmed.
I think it's in the clerk's record, 109. It says he has 25 days total jail time credit. Do you know where they got that number from?
My best guess is going to be from the jail. That is typically, they get the record of the time from that and then put it there. That's usually where that comes from. I think another point is that, you know, he's asking for this remand for this prejudice hearing, and I don't think there's any authority for that. You brought up that maybe this is better for a habeas petition. You know, you think of the ineffective assistance claims where, you know, direct appeals is not the appropriate, typically, you know, avenue for those. And so there's not any case law or statutory authority for a remand to develop prejudice. Not that I have found. I don't think that you get to go back and say, well, first of all, he didn't ever assert his right to a speedy appeal, but I don't think he gets to come here now and say, I was denied this, and please remand so I can develop prejudice in the record.
What about for the additional New Mexico jail time credit? Would that be something that would be supportive of a remand to determine what that period of time was?
I don't know where in the law there is availability to do that. I think that's the problem with the situation.
Well, if that happened after the judgment here, I mean, we wouldn't, in a normal appeal.
Right.
This is not normal, I guess, but in a normal appeal, we wouldn't consider factors that are outside the current appellate record.
Right. And I think that goes back to what all the cases say is you do have the tools to make a decision in this case based on only the record, because you can weigh those Barker factors. And yes, it's unfortunate that he spent this time imprisoned in New Mexico and is not getting credit for it, but that's not before the court. I mean, that's
If we did remand and he served more than 18 months in New Mexico and he gets credit for it, then is the appeal dismissed? I mean, we don't have to write anything on it because he served his time and he got his credit.
if there is an avenue to remand and he gets the credit, I guess that is an option that he has, is to dismiss the appeal. But again, I don't know that there's authority to do that. I think you're creating a process that doesn't exist when you remand for those fact-finding issues. And I think one of the things I thought of is if the court's going to be concerned with the policy they put forth, if they don't remand, you know, are you saying, oh, this action is okay? And again, these cases all speak to the fact that they say, you know, this delay is not okay. However, you still have to meet the due process or, you still have to prove that there was a due process violation. And because that doesn't exist here, then, you can condemn the clerk while saying, we're also gonna follow the law.
So does that require us to say a 5-year delay is not a due process violation?
I think it does. I think you can say it's unacceptable, but it's only one of the factors that we weigh. And when we look at all of the factors put together and do that balancing test, the other factors, especially the fact that there was no prejudice, no impairment of his appeal. I mean, it's significantly delayed, but he's here now. And so he's having his appeal heard. Yeah, I think you can still say, no, it per se is not a due process violation. And I think that's what the other cases support in, that deal with the speedy appeal issues.
I know your time has expired, but can you offer any assistance in how we prevent this from happening again? Maybe not we, but a
In
collective
general?
we.
I mean, I think there has to be maybe, prosecutors, we don't police the clerk's actions. For me, it's about putting in place a better process for checking up on these pending cases. And I mean, honestly, I think that has to be an office to office thing. I don't know that you can, say, you have to do X, Y, Z. But, certainly it's something it's one of those things. I don't think it'll ever happen again, at least not in Castro County, as long as I'm there, because I'll be checking on it. But I don't know as a whole how you can prevent that, because we are our own individual offices and have our own responsibilities, and typically are not checking to make sure the other is doing their job properly.
Any further questions? Thank you.
Thank you.
Mr. Pruitt, you have a 5-minute
Just
rebuttal.
very quickly again. I think it's clear and maybe maybe conceded even there was a due process violation. 5 years, it's now 6. That's a violation. The question though is there a remedy? I believe that's the question. Is there a remedy? The courts recognize that there are due process violations may arise from delay in the appellate process.
Following on Justice Parker's last question just a minute ago, wouldn't you agree that if an appellant timely asserted a speedy appeal right, that would be one way to keep the process moving along?
That would be. That would be. I believe though that
it benefits the appellant to have the speedy appeal, so why not keep the burden on the appellant to be the one to move the appeal along?
Well, for one thing, that I'm not disagreeing with that, but isn't it is it Rule 31? I can't remember where I wrote it down. It's Rule 31 or 32 that says the responsibility for ensuring timely compliance with the appellate process is on the trial court, the appellate court, and the clerk. It doesn't say the appellant. I know that's case law though, but the appellant, his lawyer did check. His lawyer checked it. Again, that's not in the record. And to the extent it is, it's just an unsworn motion filed by his lawyer. His lawyer said, here's what I did. That's unsworn, it's filed by the lawyer. It is in the record. But if that is determinative, then that's another reason for remand. Were there other things that he did to push this along that I'm unaware of at this point? Maybe his former lawyers, he's had at least 2 before me. Maybe they did other things. I don't know. There's been no ability to put anything in the record since 2019, I guess. other than his lawyer filing that.
What authority do you have, for us to remand?
I can't find authority that is specifically on this point. I can't find it. But that's the beauty of this court. You get to be the authority.
I've not looked this up, but just hypothetically speaking, if we were to affirm and then mandate issues, his appeal bond surrendered, can you get an appeal bond if you filed a petition for discretion review with the CCA?
I don't even know who would grant that. Who would set the bond? This court doesn't set bonds, do you?
We have the power to, but not generally.
Oh, I didn't even realize that. There you go. I learned something. A petition for discretionary review. I guess the next thing would be to file a request for a bond in this court if it's affirmed. Request for bond. I don't think that he would be able to file a writ while this is pending.
That was my next question. I didn't think you were able to file a writ if there's a PDR pending, but I'm not for sure on that.
I'm not either. And that's, again, the reason why we request a remand is if there was a due process violation, which we know there was a long time, did it comply with the factors that would allow, were the other factors, that he pressed forward, that he asked for in the speedy appeal, that he suffered damage, those things. Those things, there's never been an opportunity to supplement the record, to put those things on the record. And if that is, that's our position, and he wouldn't be able to put those things on the record unless there is a remand. While this is pending, I don't think he can file a writ. But I'm not an expert on writs and pending appeals. It was in this cause number that is under appeal that the clerk failed to forward the record or notice of appeal, pardon me. It was in this cause number. Did he suffer harm? That's our position, is that it has to be remanded in order to put that on the record and make the determination. Then we can appeal that from the court. If the court rules against us, we appeal that. I think my time's up.
It is, I was just,
Staring zeros at me.
did anyone else have a question? Okay, thank you.
Thank you.
The case is submitted. We appreciate the opportunity to address these issues at oral argument, and I hope it's not another 13 years before you get to come back. And if there's nothing further, we'll be in recess.
All rise.